urgency is this, my lord, the petitioner, my lord, appear in the for admission test of, my lord, admission of the class 6. And my lord, he applied for under the quota of, my lord, the OBC A category.
In
now
which school?
OBC Muslim community. So now,
in which school?
My lord, this the Johor Navodaya Vidyalaya, my lord, this the South Chobbish Pargana, only one school. So now a panel, my lord, merit list has been prepared, wherein, my lord, this the petitioner has been selected at serial number wherein in 12. So now, since he has been, my lord, subsequent the judgment of this honorable court, my lords, the OBC certificate has been cancelled. That's why his candidature has not been considered. So now, as per the score sheet, my lords, he got the 95%. Now the general candidate, my lord, got, my lord, the last cut of marks 92%. If the petitioner candidature is considered as a general candidate, he may be, my lord, this, my lord, admitted in the school. So now, since the panel has been, my lord, merit list has been prepared by the central board, so that's why the school is not in position to give, my lord, the allowed to admit the petitioner. That's why, my lord, this 26 is the last date. So either, my lord,
this is the last date. Is it
26th of April.
CBSE school?
My lord, under the control of the CBSE, because of the Johor Navodaya Vidyalaya, that panel, my lord, merit list has been prepared by the central, my lord. So, my lord, this is the, I have annexed all the documents, last cut of marks, and, my lord, his serial number, merit list.
Have you made CBSE party?
Yes. I have, my lord, I have made all the, my lord, the respondents, including, my lord, the district magistrate, who is the chairman of that.
26 is the last date.
Last date, my lords. My lord, the merit list has been sent by the.
When the merit list was published?
My lord, 20, my lord, the 20, my lord, the 27th of March. I have been.
What you are doing for such a long time?
I have been intimated to submit those documents. I went there, my lord, is the last 21st of April. So now I could not, my lord, submit the OBC certificate because of that. My merit list had been prepared under the category of OBC. So that's why my
school is not shifting you from OBC to general.
No, they are not in because of the.
But if you are considered as a general category candidate, you are coming within the zone of consideration.
Yes, my lord, 95% are last cut of marks that has been published in the website.
That's the general category.
92%.
But how you will effect service? CBSE has to be heard. School has to be heard.
My lord, in course of day, my lord, I will send mail as well as, my lord, the speed post. My lord, because of the
you should have filed it earlier.
My lord, yesterday I have went to the, my lord, chairman. This is the district magistrate on 21st for, my lord, ends of justice.
Well, tomorrow. My
lord, this kind of grateful to Lord.
May I be granted leave to mention, my lord? This was, my lord, disposed of just before Easter, 21st of April. Sir, may I pay for small modification, my lord? Since, my lord, the mutual transfer, there is no direction for the SSC to, after my complaints.
Sorry, you have to file application.
Yes,
sorry.
I shall come up with that.
Sorry.
With the application.
Modification. Item number 1. এইদিকে পাখা চালাতে এই দুটো পাখা চালাতে বলো Yes.
After passing of your lordship's order, the district magistrate has already given the legal heirship certificate. Now, I don't know the reason, my lord. There may be some problem in the server. Till today, my client has not yet received anything.
Your client
Has not yet received any pensionary benefit.
pension payment order has been issued. Yes.
My lord, my lord, e-portal is not operational.
Yes.
E-pension portal is not operational right now. So, my lord, this instruction already.
Manually issue pension payment order.
My lord, all details should be filed through the e-portal.
You manually text. Have you forwarded the legal aid certificate to the district?
Yes,
schools?
I have
Input
forwarded
it
to the DI
No, my lord.
and also
I have
intimated to
passed
the-
this order on 11th of March. I will stop the salary of DI.
My lord, this have kindly stay instruction.
Forget about instruction. Take steps manually and issue the pension payment order. Is it a ground? Lady has lost her husband in 2022. Till date, no family pension.
And DA has tired his level.
Shall I direct the authority to stop salary of your DI?
No, my lord, I take instruction. I convey this message.
Money is going on.
As the pension portal is not in operation.
When you have forwarded Mr. Jana pension, this legal aid certificate?
19 April 2025.
19 March.
19 March, sorry.
19 March. Then from which date your portal is non-functional?
20th March.
Error in my lord, processing in portal. You will see direct the DI manually, my lord, to forward the pension. Otherwise, it will not be solved.
That could not have been done in view of the order passed by this court.
Operation since 20.
Whether this court directed that completing the process online, this family pension has to be released. This should have been done by your DI.
My lord, DI is tired.
Come to the order passed by this court. Come to read the order, relevant part of the order. 11th of March 2025 order. Order copy nahi. Read it loudly. Read it loudly.
In terms of the order dated 4th March 2020.
No, come to the third page of the order. First paragraph, the headmaster of the aforesaid school is directed to obtain. Read it loudly.
Directed to obtain legal aid certificate from this office of the district magistrate concerned, being respondent number 6 by 10 days from the date of submit this same before the district inspector of school AC. Say Hubli, being respondent number 5 by 48 hours thereafter. On receipt of legal aid certificate, respondent number 5 till immediate steps for release of the family pension in favor of the petitioner. The director of pension provident fund and group insurance, being respondent number 3, is directed to take necessary steps for issuance of pension payment order in favor of the petitioner. This matter under the same heading at the.
Sir, have I directed that through by completing process online, it is to be released?
My lord,
Under court's order, this could not have been done. Yes.
My lord, keep us some time, my lord. I convey this method. They will comply this order.
Where the pension payments pension case is lying, papers relating to the pension of the petition is lying.
My lord, since
where it is lying?
DI office.
March 22.
Where pension payment pension papers are lying?
Pension paper कहाँ है?
Office of the DI. Office of the DI.
Why he has not forwarded it? From which date your portal is non-functional?
20th March.
20th March. Up to till date.
Yeah.
And then in terms of the order of the High Court, manually this could not have been done.
No, my lord, they already.
Well, I shall direct that authority to stop salary of DI.
My lord.
Then he will face the music.
My lord, kindly allow sometimes I convey this message, my lord.
Since the portal is not,
Mr. Chattopadhyay, please come forward. You are the additional government pleader. DI Hugli,
ম্যানুয়ালি পাঠায়নি কেন?
Court has directed specifically on 11th of March. Legal year certificate was submitted on 19th of March. And you appear in this matter, otherwise there will be an adverse order against the DI.
কোনো কথা বললেন না ভাই, ওটা ভাই হাতে একদম দিয়ে দেবেন।
Have I directed that to complete the process through online?
এতদিন আগে রিটায়ার করেছে পুলিশ।
মারা গেছে
হ্যাঁ বুঝতে
2022 থেকে মারা গেছে 25
ওটা অনলাইন
এসো
অনলাইন
It is submitted by the learned advocate representing the petitioner that in terms of the order dated 11 March 2025, till date, family pension has not been released in favor of the petitioner. Stop. Next paragraph, learned advocate representing the school authority has submitted that legal aid certificate has been issued by the appropriate authority and same was forwarded to the office of the district inspector of schools, AC Hooghly on which date? 19 March. On 19 March 2025. Stop.
Reminder on 11 April.
This court is next paragraph. This court is astonished to find. This court is astonished to find that in spite of specific direction given by this court, video order dated 11 March 2025, till date, family pension has not been released in favor of the petitioner. Hearing of this matter stands adjourned till Seventh May 2025, when it will appear at the top under the same heading. For compliance of the order dated 11 March 2025. Stop. Now, stop the honor. Failing which, appropriate order shall be, failing which, District Inspector of Schools AC Hooghly shall be appropriately dealt with. Next paragraph. Mr. Supriyo Chattopadhyay, learned additional government period, is present in court, who is requested to appear in this matter on behalf of the state respondents. And use his good state respondents. Stop. It is expected Mr. Chattopadhyay shall take necessary steps for compliance of the order dated 11 March 2025. Take it back.
grateful.
It is expected না করে বলো Mr. Chattopadhyay is requested to take necessary steps for due compliance of the order.
Item number 2.
I am for the petitioner, my lord.
I am for the commission.
So far as the service upon the school authority, my lord, and I served on 29th of March.
Service is not complete.
I served it on 29th of March, my lord. But till date, my lord, the website is not updated, my lord. Can you kindly see, my lord?
What is the matter about?
There is a transfer on distance ground, my lord.
The serve and come back issue. At the time of call, learned advocate representing the petitioner has prayed for accommodation to it. Prayed for accommodation to serve to complete service of notice upon the respondents, upon all the respondents. Stop. However, state respondents and West Bengal Central School Service, however, state respondents come on West Bengal Central School Service Commission. Now, however, some of the respondents are represented today. Next paragraph. Learned advocate for the petitioner is directed to complete service of notice upon all the respondents by 10 days from date and file further affidavit of service and file affidavit of service on the next date. List the matter under the heading motion under the same heading on 13th May 2025. Next.
Item number 3.
Lordship, I am for the petitioner. Lordship, there is a can on the last occasion. The can was not tagged with the main application.
Yes.
Lordship, kindly come to para 5 of my application. of my can application, Lordship. That is for the rectification of the spelling of the petitioner's name.
Right.
Paragraph 5.
Paragraph 5. Paragraph 5, relevant portion, page 3.
Paragraph 5.
Paragraph 5 of the can application, Lordship.
Paragraph 5 of can application. What are the corrections which are required? You indicate from the writ petition.
Lordship. Lordship, very small correction. The name only is KHAKON.
Where?
First title, Lordship.
Yes.
Lordship, the spelling is KHAKON and that would be KHOKAN.
Only this correction.
Only this, Lordship.
Issue. Application being can 1 of 2025 is taken out by the petitioner for correction of the writ petition being WPA 7279 of 2025.
Paragraph 3. Paragraph 3.
Stop. It is pointed out by the learned advocate representing the applicant that spelling of name of the writ petitioner in the cause title of the writ petition should be KHOKON instead of KHAKON. Stop. Next paragraph. Leave is granted to the learned advocate for the applicant writ petitioner to amend the cause title in course of this day, thereby describing the name of the petitioner in the cause title appropriately. Next paragraph. List the matter. Next paragraph. Application being can 1 of 2025 stands disposed of. Next paragraph. List the matter under the same heading on Monday next or on Tuesday, on Wednesday next, 30th April 2025. Next.
Well, just have a talk with the LTI. Just taking steps, my lord.
Item number 4.
Not this evening.
At the time of call,
Mr. Kamlesh Bhatt.
at the time of call, accommodation is paid for on behalf of the petitioners. Next paragraph, list the matter under the heading motion in the monthly combined list of May 2025. Next.
Item number 5.
Yes.
I served the copy, my lord.
Who is for the petitioner?
I am for the petition, my lord.
Yes. What is the matter about?
Matter, my lord, the petitioner is appointed, my lord, is a teacher, assistant teacher or class 11 and 12. But, my lord, the private respondent, my lord, was appointed a casual part-time teacher. He was, my lord, disturbed the petitioner for imparting education to the student. And several representation made. He is not a para teacher. He is a casual part-timer, but backdoor process.
Who are you?
I am the teacher, assistant teacher.
We are praying that not to engage casual teachers.
To remove the private respondent as a casual part-time teacher.
How you are affected?
Affected, my lord, he disturbed my imparting education, my lord. That's why, my lord.
Why? It's a decision of the managing committee of the school. Are you a part of the managing committee?
No, my lord, I am not a part of the managing committee.
How you can make a prayer that remove another teacher working in the school?
But as per law, my lord, the law says, my lord, as per
that will be decided by the concerned respondent authorities, state respondents, as well as the school authority. How you can make such prayer?
Representation, my lord, before the authority concerned.
If you make a representation that part of government should be settled in your favor, that representation will be considered.
No, my lord.
Then,
but the law says, my lord, after Expenditure Control Act, my lord, 2005.
So that will be taken care of by the managing committee. You are not a member of the managing committee. How you are affected?
But school authority.
How you are affected?
My lord.
Yes. How you are affected?
Private respondent, my lord, for disturbing me, my lord, to impart education. And my lord.
You are a teacher of which subject?
All science. For
That's why another teacher who is working on casual basis should be removed.
Yes, when the permanent teacher came, that the casual teacher will not be.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, a queer prayer Q-U-E-E-R, a queer prayer is couched in this writ petition, directing writ petition for direction upon the respondent authorities to remove another teacher in the who is working in the school. In political science, now who is working in the school as a teacher of political science, since petitioner is also a teacher of political science in the same school, it is submitted that petitioner functioning of the petitioner as assistant teacher in political science in higher secondary section is being disturbed due to presence of respondent number 8.
Yes.
Due to presence of respondent number 8. However, nothing has been narrated as how functioning of the petitioner as a teacher, how functioning of the petitioner is being affected due to presence of respondent number 8. Stop. It is also submitted that respondent number 8 was not appointed. Now, respondent number 8 is working in the school
But backdoor
as a
process.
part-time teacher. Therefore, he has no right to function as
Casual part
as an assistant teacher of the said school. Next paragraph. However, on query being posed to the learned advocate for the petitioner, it is answered that petitioner is not the member of the managing committee of the school. Stop. Retention. Next paragraph. Retention of respondent number 8 as a part-time teacher is required to be decided by the concerned respondent authorities. Is required to be decided by the concerned respondent is required to be decided by the managing committee of the school as well as state respondents. Stop. It is expected that respondent authorities shall take steps accordingly with regard to retention of respondent number 8 as part-time political science teacher of the school in question. Stop. Respondents, concerned respondent authorities are also now a school authority is also directed to take necessary steps so that functioning of the petitioner as assistant teacher of political science may not be affected. So that functioning of petitioner as political science teacher of the school should not be affected due to presence of respondent number 8. Next paragraph, writ petition stands disposed of. Next.
I am for the statement.
Give your appendices.
Item number 4, I was for the statement.
Yes.
Item number 4, I am for the statement.
Item number 6.
Yes, I have passed an order. Give a আগের অর্ডারটা ওকে একটা appearance record করে দাও তো। হ্যাঁ, order is passed.
Transfer would have pending.
Give your appearance in the previous matter. Yes.
Item number 6.
In this matter, my lord, Mr. Mitru is appearing for the School Service Commission. My lord, we have some difficulties, my lord, with regards to my lord, collection of briefs from the commission, my lord.
What is the matter about transfer?
Transfer, my lord. So, my lord, I am praying for accommodation, my lord, since my lord commission is
At the time of call, accommodation is prayed for on behalf of West Bengal Central School Service Commission. Stop. Stop. However, petitioner and state respondents are represented by learned advocates. Next paragraph. List the matter under the same heading on Tuesday next, comma, on Wednesday next, comma. 30th April 2025. Next.
May I file the affidavit of service?
No.
Item number 7.
Your Lordship, on behalf of Dr. Sutanu Kumar Patra for the School Service Commission, I am praying only not today, my lord.
For the petition.
Yes.
On behalf of Dr. Patra, I am praying not today. He is engaged in a contempt matter before the division bench, my lord. Court number 26.
Not today.
Not today. Deeply obliged.
Item number 8.
Item number 8, I am for the petition. My lord, this is the transfer application on self-medical ground of the petitioner. My lord, status is page 31. My lord, it is the case, my lord. The transfer application of the petitioner is stuck in the end of the DI after medical verification of the petitioner. Last application, so far previous application is concerned, previous application back from the School Service Commission.
Yes, yes, page 31.
Page 31.
Transfer application on what ground?
Last application on self-medical ground.
What is the date of that application?
The date of the application is 13th of August 2022. It has been forwarded to the school from the school to DI on 29th of August 2022. My lord, on 16th September 2022, petitioner was examined.
But previously, it was said that the disease not included in the disease as per GEO.
As per GEO,
yes.
But my lord, it is also on the self-medical ground.
Maybe, but if disease is not a specified disease, is not a specified, then why it was observed, why it was endorsed by the DI?
That is the question. My lord, gynecological disorder previously also mentioned. If I am not qualified, that it may endorse.
And
that.
Previously you applied under the on the ground of distance also.
Yes. Distance ground, my lord, back from the SSC that I have secured less score in the preferred school.
So if you are suffering from gynecological disorder, then why this previously this application was filed on 9th of March or previously on 22nd of August 2020, 29th of August 2021 on the ground of distance?
29th of August 2021.
Yes. They again on 11th July 2021.
11th July 2020.
That was ended up with an endorsement that it was not a specified disease. Then prior to that on 29th August 2021.
Only one application?
Yes. So if she was suffering from gynecological disorder, then why an application was made on the ground of distance?
My lord, subsequently it is a change of circumstances.
What change of circumstances?
Petitioner became seriously ill. My lord, it is difficult.
From which date she became ill? Where you have stated in the writ petition?
My lord, I have stated in writ petition in my lord paragraph number 7. Petitioner became seriously ill and
from which date?
My lord, in the month of July, the change of circumstances in the month of July, my lord, petitioner.
No, from which date petitioner became ill?
That
after 9th of August, probably 2022, page 29. Page 29, serial number 4. DI secondary to HY, disease not included in the list as per disease.
Yes.
Then my lord, HY backed it to the applicant on my lord 8th of August. Then on 13th of August, petitioner again my lord applied on self-medical ground.
No, previous application was also on medical ground. So what was the medical, what was the ailment? What was the disease?
Gynecology. That I have stated. Yes, I know.
Then why it was stated that it is not a specific disease?
If I am not qualified, then it is not. It should be mentioned that you have not. CMO is returned back your application that the illness is not so serious, but his endorsement is not correct. Illness may be illness. Illness is not notified disease. It should be endorsed like that.
Whether you were medically examined in connection with your previous application?
Yes, both I present last application on 16 September 2022. I have been examined by the CMO.
and it is the documents regarding to also
Required documents submitted through portal forwarded to. So what are the required documents which has been endorsed against 29th August 2022?
29.
Page 31. DI send it back to the school.
Malad 29.
Required documents submitted through portal forwarded to the DI of schools AC Purulia.
Malad HY forwarded it to the DI.
The DI for the medical verification.
And it is the remarks of the HY.
Oh. So in connection with your previous application on medical ground dated 11 July 2022, you are medically examined.
Yes.
Where is the report?
Malad that report I have not.
And in connection with your last application dated 13th August 2022, you are medically examined.
Yes. 26 September 2020.
But you are not aware of the report.
No. Subsequently, portal is suspended.
So very well, then you file a report, DI to file a report, disclosing the medical report. Ish. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner made last application for transfer on self-medical ground.
Yes.
On self-medical ground, since she was suffering from gynecological disorder on 13th August 2022 on Utsosi portal, which was forwarded by the school authority where petitioner is presently working to the District Inspector of Schools AC Purulia, being respondent number 5 for taking further steps. It is submitted on behalf of the petitioner that she was medically examined in connection with her transfer application dated 13th August 2022. But the medical report was not made available to the petitioner. Next paragraph, state respondents are represented by learned advocate. Stop. Advocates for stop. Respondent number 5 is directed to submit a report disclosing the medical report in connection with last transfer application of the petitioner dated 13th August 2022. On the next date, list the matter under the same heading or list the matter under the heading motion on 14th May 2024. Next.
Item number 9.
Assembly of the state led by my senior Mr. Shogota Mitru.
In item number 9, similar prayer, my lord. Mr. Mithu is appearing
Yes,
because he has not received the brief.
At the time of call, accommodation is paid for on behalf of the petitioner. At the time of call, accommodation is paid on behalf of West Bengal Central School Service Commission. However, petitioner and state respondents are represented by learned advocates. Next paragraph, list the matter under the same heading. On Wednesday next, 30th April 2025. Next.
Item number 10.
Mr. Mithu. My lord, I am appearing on behalf of the state.
Same order. और ওটা ওই ডেটটাকে এবার একটু চেঞ্জ করো অন ওয়েডনেসডে নেক্সট 30th of April ডে বদলে আচ্ছা থাক 30th নেক্সট হ্যাঁ হ্যাঁ ঠিক আছে তারপরে
Item number 11.
state respondents.
The time for the
Petitioner before your
Page 19.
is a
In prescribed pro forma?
prescribed pro forma
without the NOC of the Malad school.
school, but
Only Malad he has signed.
Page 19.
my lord,
Yes, yes.
20 and onwards. Page 19, it has been received by the school authority, 4th of March 2025. My lord,
No date, nothing.
No. Last.
Yes, page 21.
My lord, page 19, I have given this copy with an forwarding. My lord, kindly.
No, in page 21, where is the date? At the bottom?
Page 21, my lord, no date.
Why?
My lord, page 19, I have given this copy.
No, why there is no date in your application? Only to file a writ petition, these applications are being made. Nothing else.
Page 20.
Where is the date?
My lord, I have given.
Court will consider the undated application.
My lord, kindly come.
Page
My lord, page
23 is
19.
also blank, my lord.
My lord,
Yes, 23 is also blank. Yes.
my lord, page 19, kindly come. Page 19.
No, in the prescribed for pro forma way, the date has not been put in. Answer the query of the court first.
That I.
Everything should not be dealt with in a casual fashion.
Right. School.
Schooler পার্টটা তো স্কুল কোনো fill up করেনি।
NOC has not given. My lord, I have given this.
Where is the date of your application?
Prescribed format, there is no.
Why not?
My lord, it is the mistake.
Withdraw the writ petition, prefer an appropriate application and then come back.
Your lordship so desire, my lord. But my lord, the school has received it, their prescribed format, my lord, by endorsement.
Which endorsement?
Yes.
But in our copy, there is no such endorsement.
Page 19.
No, there is an endorsement by the school authority.
Yes.
4th March 2025.
In our copy, there is no seal.
Why? Kindly
Page
19. Our copy, there is no seal. But our copy, there is a seal.
It is zero.
নেই আমাদের নেই
আমার কপিতে নেই। Kindly have a look at জোসেফ কেটা দেখান।
Dear document just beside me that.
My lord, in board copy, there is, my lord, some. My lord,
Yes, it's not legible.
Legible.
It is not there practically. Not properly.
board copy of the board copy, there is.
Yes, then your grievances against the school authority.
School authority.
Have you served notice
Yes.
upon the school?
Thank you.
It is application on the ground of distance.
No, my lord, I am physically disabled person, 60% disability. My lord, previously I applied in the Utsos reporter. The school given the NOC and it has reached to the commission. But at that time, my lord, there is no vacancy which I have selected, which has been filled up. Accordingly, they requested me to return back my application. By my instance, it has been returned. Presently, my lord, there is a vacancy. So since the portal is suspended, I made an offline application. This is the sum and substance.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. It is submitted by the learned advocate representing the petitioner that an offline application in the prescribed pro forma has been preferred by the petitioner seeking transfer since petitioner has more than 60% disability.
Yes, I have
has
60%.
Has 60% disability.
And non-progressive it is.
Stop. Application was submitted by the before the authority of Jair, Jair, Jair High School, Hooghly on 4th March 2025. But said school authority has not issued no objection for transfer of the petition. Next part. In spite of service of notice upon aforesaid school authority, upon the said school authority, being respondent number 6, comma, headmaster of the said school is not represented today. Next paragraph. This court desires to hear respondent number 6 on the next date, since grievance is against the respondent number 6. Next paragraph. Learned advocate for the petitioner is directed to serve another notice upon respondent number 6 enclosing copy of this order by 10 days from date and file further affidavit of service on the next date. Next paragraph. However, it is made clear if, in spite of service of notice, respondent number 6 is not represented on the next date, matter shall be heard in absence of respondent number 6. Next paragraph. District Inspector of Schools AC, Hooghly being respondent number 5, is directed to submit a report disclosing as to why till date school authority has not issued no objection in favor of the petition. Next, matter to appear. List the matter under the heading motion on May 2025. Next,
Item number 12.
And for the state respondent, led by Mr. Amitabh Mitra.
But I am for the
state.
If you see here,
Who is for the commission?
that the commission is served. Sir, 9th of April, sir. I shall come back with a further notice.
Yes.
I shall come back with a further notice if your lordship desire.
Well, not today.
School is also important.
Not today.
Lordship.
Let me see whether commission appears tomorrow. Next.
And for the petition of my lord.
Item number 13.
And for the petition of my lord. Well, the matter is about CPF to GPF shifting, my lord. Petitioner's husband was the employee, my lord, and he has been retired from the service on 30th/6/2000, my lord.
What you are praying for?
Paying for the area pension, my lord.
From the date following the date of the husband, or husband died in harness, or after retirement?
No, after retirement, my
After
lord.
retirement. So from the date following the date of retirement of the husband of the petitioner till the date of refund.
Yes, my lord.
So I have passed similar order in case of husband. Give me the order.
I don't have an order, your code, my lord, but I have an order, my lord. Justice Amrita Sinha, my lord.
No.
Just have an order.
Madam.
এই দেখো তো হাজবেন্ডের ক্ষেত্রে যেখানে মারা গেছে ভিডিও আসছে।
order আছে। জানার কাছে অর্ডার জানার কাছে
assistant teacher.
assistant
Husband was assistant teacher.
yes
একটা কপি বার করে নাও তো। WPS 17 পেয়েছো? देखिए না এটা একটা কপি বার করো 17274 of 2023. When the husband retired?
30th
June.
2000, my lord.
মারা গেছে কবে যে 18 মারা গেছে কবে দেখে রাখবে জিজ্ঞেস করবে।
When husband died?
2016, my lord.
9 November 2016.
16 মাস। দুই এক 15 জিজ্ঞেস করবে কবে থেকে পাচ্ছি ওটা জিজ্ঞেস করবে দেখে রাখ।
Pension payment order?
Pension payment order, my lord.
15 কত 15 আছে তার
12 June 2015.
12 June 2015.
page 23.
Just a minute.
দাঁড়াও দাঁড়াও যখন জিজ্ঞেস করবে তখন তো ওটা আছে ওই অর্ডার। হ্যাঁ তোমার তো 2 তারিখ থেকে পেয়ে ওই ট্যাপের 2 জানুয়ারি। বোঝা যাচ্ছে না একদম। 2 জানুয়ারি 15 মনে হয় না।
Yes, disposed of. এটা ফলো করে দেবেন। Item number 14.
Madam, this is my affidavit of service.
Greenmala big to appear for the Madrasa Authority.
But petitioner is a
State responsible.
But the petitioner is a retired clerk of the respondent Madrasa Malar who retired from service with effect from 31st March 2025 Malar. But just at the verge of his retirement, Malar, petitioner has been served with a suspension notice, Malar, suspension order, Malar, by the managing committee on the allegation that some land of the madrasa has been transferred in the name of the petitioner, Malar.
Some land of madrasa was
transferred in favor in the name of the petitioner. Although, my lord, I have purchased the subject land from
Petitioner
the
was an
clerk.
Clerk. 31st March 2025 retired.
Retired. My lord, I have purchased the subject land from the original Rayat, my lord, by virtue of two registered sale deed, my lord. My lord, my lord,
From Madrasa?
no, original Rayat. My lord, I have denied all the allegation, my lord. My lord, initially, my lord, on 3rd January 2025, my lord, board had issued a, my lord, directed the madrasa to show cause, since, my lord, admittedly, my lord, the land of the madrasa cannot be transferred. But that's why,
No,
my lord,
but prior to your retirement, any proceeding was initiated?
no, nothing, my
You
lord.
are for the state.
I'm for the madrasa.
Madrasa.
My lord, nothing has been initiated, my lord, only suspended. And, my lord, I am not getting the pensionary benefit, my lord.
If you are suspended, then how you can get the benefit?
No, my lord, as per the DCRB rule, my lord, if there are disciplinary proceedings or judicial proceedings is pending, my lord, I am entitled to get the, my lord, the provisional pension at least. And, my lord, here, my lord, no, my lord, the disciplinary proceeding has been initiated in
Now,
terms of
what steps board has taken?
my page.
But whether the managing committee can suspend now, no?
Kindly come to
Oh, it's madrasa. Yes, it's madrasa. No, you are suspended. Now your suspension order has been approved by the board.
It has been sent to the board. Board is under process.
Who is appearing for the board? Yes. Where is he? Have you served notice upon the board? By hand. Now, but till date, suspension order has not been approved by the board. What is the date of suspension order? Where is the suspension order? In madrasas, similar rule of 28(8) is still followed. 2002, but the contents of the rule is same. Now it is suspension power to suspend lies with madrasa or with the board.
Because previously they are for the schools also.
তাই তো দেয়নি, কি বলেছে রিপ্লাইটা দেয়নি, বলতে হবে। এই তুই রিপ্লাইটা দিসনি কেন? তোর কাছে রিপ্লাই কোথায়?
Then how the madrasa has decided to suspend him?
On 5th of January.
Page 69.
Yes, what I'm telling you. So what the petitioner has done, not he has allowed a third person to transfer the land in his name. Thereafter, he purchased from him.
The land of the madrasa.
Yes. He allowed a third person to purchase it in his name. Then from him he purchased.
So, but in case of purchase of land of madrasa, then the due resolution of the managing committee of madrasa is required.
Nothing.
How this can be? But how this purchase, this execution of deed took place? It cannot be registered unless and until a decision is taken by the managing committee of the madrasa. Because he has no authority to sell the land of madrasa. It is the president and secretary with the resolution backed by the resolution of the managing committee can be done, must be with the approval of the board and the DI.
I am the.
Otherwise, how the land can be sold out in favor of third person? Forget about the clerk. Whether the land of madrasa can be sold out at the instance of the clerk of madrasa, this cannot be done.
No, kindly see the deed, my lord. Who has sold it?
Now, what steps the board has taken?
We have sent it to the board.
When you have sent? 18th March. Yes. Thereafter?
18th March, just yesterday, the Madrasa Authority inquired from the board said that this is in process. In process. Because at the instance of the board, we have so caused and thereafter suspended. Kindly see,
but you are saying that the suspension does not lie in the hand of the madrasa. Power to suspend. It is to be suspended. The suspension order is to be issued by the board.
No.
You can send a proposal for suspension.
No. This is madrasa.
Yes.
And 2002.
Show me 2002 suspension.
Just a minute. Just a minute. An example of madrasa. Headmaster's manual madras. এটা দাও
Indian 100 rules 2002. Yes. Which rule?
ল্যান্ডটা কিন্তু মাদ্রাসার নামে হয়ও নি, আগের মালিকের নামে তো হয়ে গেছে, এমদাদুল।
But it is you are saying that it is to be the suspension order is to be issued by the board. That is not correct. 28(1) says that in an aided and unaided madrasa, committee shall have the power to place an employee of madrasa under suspension. Why you are saying that the madrasa the board can suspend, not the committee?
I am not saying. I am not saying.
So if he is suspended, then where is the right to get pension at this stage? But if you are suspended, you are not entitled to get the pension now. Yes. Pay provisional pension.
Provisional pension is
entitled. Provisional pension and provident fund. Yes, yes. Gratuity he will not give.
But this prayer is kindly seen here.
Whatever may be the prayer, but whatever which the prayer which is permissible under the law, that is to be granted by the court. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate representing the petitioner submits that petitioner was a clerk of Horipur High Madrasa within bracket HS, Dokhin Dinajpur, who retired on superannuation on 31st March 2025. So, grievance of the petitioner is in spite of superannuation of the petitioner with effect from 1st April 2025 till date retirement dues have not been released in his favor. Petitioner prays for necessary direction for release of retirement dues expeditiously. Next paragraph. State respondents and madrasa authorities are represented by learned advocate. Stop. It is submitted by the learned advocate representing madrasa that based on certain allegations relating to purchase of land by the petitioner, a suspension order was issued against the petitioner on 18 March 2025, and the proposal for suspension was forwarded by the Madrasa Authority to the West Bengal Board of Madrasa for approval. Stop. It is submitted. It is further submitted on behalf of Madrasa Authority that on query it is informed that board is taking steps to decide on the fate of suspension order dated 18 March 2025. Stop. Today board is not represented. Today, next paragraph. Today West Bengal. Today board is not represented in spite of service of notice. Next paragraph. Notwithstanding pendency of suspension order and disciplinary proceedings / criminal proceeding in terms of relevant provisions of Death Cum Retirement Benefit Scheme 1981, petitioner is entitled to receive Provident Fund and provisional pension. Stop. Concerned respondent authorities are directed to release Provident Fund and provisional pension to the petitioner by 4 weeks from the date of communication of this order. Stop. Next paragraph. Respondent authorities are at liberty to take steps in accordance with law based on suspension order passed on 18 March 2025. Stop. Writ petition stands disposed of. Urgent xerox certificate.
No.
Next.
But we have also, I have challenged the suspension order. If it is disposed of, otherwise I will be in difficulty.
Yes.
Ultimately, the
suspension, fate of the suspension order has not been decided by the board till date.
Yes, ma'am. That's why, I am praying, since I have prayed for setting aside the decision of the managing committee,
but unless and until it is, who knows? Ultimately, board can disapprove the prayer for suspension.
Ultimately, otherwise,
or proposal for suspension.
Otherwise, it will be barred by res judicata.
Yes.
It will be barred by res judicata. Subject to Malas kind.
I couldn't follow what you were subject.
Otherwise, it will be barred by res judicata. If it is challenged, subsequently, the prayer is there, kindly say.
But I have directed that they are at liberty to take steps in accordance with law.
Consequently, if you feel that suspension order is illegal, you cannot find.
Otherwise, I'll be in difficulty.
Because the main chair.
That's an issue. We can record the board is directed to take decision on the fate of the suspension order by 6 weeks from the date of communication of this order. Last paragraph take a follow.
By since my board is not represented, the order may be communicated to the board.
Yes. এইখানটা কেটে দাও। The concerned authority of West Bengal Board of Madrasa Education is directed to decide the fate of suspension order issued against the petitioner by 6 weeks from the date of communication of this order.
But one thing, my lord has can you make it clear that my lord has been pleased to not to consider the suspension order, my lord.
No, I have directed the board to take decision on the proposal. Board has to approve the suspension order.
Item number 15.
I am for the petitioner, my lord.
Who is for the petitioner?
My lord, I am for the petitioner.
I'm for the private respondent.
Just a minute.
Right? Department ke diye. Kore ki? Petitioner জানাত করে হ্যাঁ দেখলাম তো
Yes.
My lord, in this matter, my lord, petitioner was the in earlier managing committee of the school and the secretary of the managing committee. Is the my lord, he is challenged the order of the district inspector of school, which was passed pursuant to the direction of the honorable division bench of this honorable high court, but modifying the order suo motu in its own way.
Who has modified the order?
My lord, district inspector of school, where the division bench of this honorable high court directed the state to pay the interest at the rate of 7% per annum directly to the petitioner, and thereafter division bench directed the district inspector of school or commissioner of school education, who is the appropriate authority, to recover the amount from that person for whom the laches has been made. My lord, here, my lord, district inspector of school directly, my lord, without considering the order of the division bench, directly held the school authorities responsible for the delay and laches, and directly directed the district school authority.
Show me the order of the honorable division bench.
Yes.
It starts from page 53.
Page 53 starts from, my lord, and page 55.
You are appealing for?
I'm for the private respondent number 4. Mala, my appeal before
You are the school authority.
I am for the school authority.
You are the teacher.
I was the teacher. My appeal was disposed of before the division.
Page 55, paragraph 10. Relevant.
Just a minute. So in paragraph 10, it appears that it is to be paid by the state first. Then the DI and the commissioner to take steps in order to fasten the responsibility upon the person who was responsible for causing delay in releasing retirement deeds. So in the present case, what has happened?
Malat, page 59.
Till that payment
State has not made the payment. Rather, Malat called a hearing. And all the parties
that state can do, but state has to make the payment.
Page 59, last para. In view of above,
You have also caused a delay in making payment. Come to pay, paragraph 10. First you make payment and then take steps. But state can take steps simultaneously for fixing the responsibility. For that you cannot assail.
Malat, division bench order.
There are two parts. You have to understand it. Paragraph 10 and paragraph 11. Read it, paragraph 10. This court can direct to expedite payment of interest to the respondent number 4. But the steps which has been taken without making payment, that you cannot question. I will direct the state to make payment strictly in accordance with the direction of the Honorable Division Bench. But the steps which has been taken, how we can challenge it?
They have without...
Because there is a specific observation that since the state has to bear the responsibility solely on the ground of delay, issuance of no liability certificate, delay of solely on the ground of delayed issuance of no liability certificate, the concerned district schools and or the Commissioner of School Education is directed to initiate a proceedings for fixing the respondent, and in the event it is found that the school authority or the person in the helm of the affairs was responsible for the same, it is open. So no time, it is not a time-bound order.
No, man.
Is it dependent upon payment of the 7% interest? Answer is no. So on the next date, state can initiate proceedings in order to fix the liability upon a particular person.
But
that the state has done.
But prior to that, payment has to be made.
How you are interested for
because,
that?
My lord, without making payment, the order has to be complied in
these two things can run simultaneously.
My lord, the order has to be complied in two.
Yes, I will direct the state to make payment of interest to the petitioner, to the respondent number 4.
Yes.
But how you can challenge?
I have, my lord.
How you can challenge the order dated 17th February 2025?
Yes, my lord.
This challenge has to be laid independently.
Yes, my lord. I have challenged both.
You are making a mistake. There are two aspects.
Yes.
First, 7% interest is to be paid by within 3 weeks from date. That state authorities has not done. Suppose state authority pays this 7% interest after 6 months. Does it prevent the state authorities to fix the liability upon the school authority? Then
My lord, I am challenging the.
I could understand that Mr. Bari would have approached this court for non-payment of. For that, he would approach the appropriate division bench in contempt.
Contempt procedure.
But you cannot express your grievance that since interest has not been paid, no liability can be fixed upon the headmaster of the school.
No. That is not only my.
You can challenge this decision, but that decision is to be challenged solely on the ground or solely on the observation made in paragraph 10 and 11.
My lord, the decision has.
Is it a case that unless and until this interest is paid, responsibility cannot be fixed? Answer is no.
No. My lord, the division bench has not observed that the school authority is responsible. He has, my lord, relegate the issue to the commissioner or DI.
The responsibility solely on the ground.
But now the DI, my lord, without considering the contention of the school.
AC Commissioner directed to initiate a proceedings for fixing the responsibility, and even it is found that the school authority of the person in the the case of issuance of no liability certificate.
No liability certificate.
And it is to be for last 3 years. It is required to be issued by the school authority. That's why the division bench has said that to initiate a proceedings for fixing responsibility, and the event it is found that a school authority or the person in the helm of affairs was responsible for the same, it is open to the state to realize the said amount from him.
My lord, here, my lord, the private respondent was the headmistress of the school. He retired from service without handing over the charges.
I will not enter into this issue now.
That is no longer.
Sorry.
My lord, that is to be considered by the district inspector of school.
No.
My lord, why? When, my lord, district inspector of school passed the rescind order.
Why you have made delay?
Because of
it's a case of pension?
Because of the court proceedings. Petitioner, private respondents filed one writ petition in the year 2021. 2023, that writ petition was disposed of. Pursuant to the direction of the single bench, my lord, no liability certificate was issued. My lord, thereafter, my lord, challenging that order, my lord, intra-court appeal has been filed for getting interest.
What appellate court has directed? Whether this court can enter into this?
My lord, no person should not be remediless, my lord. My lord, challenging that order, appropriate forum is the writ court, my lord. I cannot go before the appeal court. In contempt jurisdiction as well as the review jurisdiction, I have only remedy before the writ court.
But
I cannot.
At the end of the day, the authority, school authority has not issued no liability certificate.
Why? That is to be considered by the district inspector of school. While, my lord, considering the case of the delay and laches in issuing no liability certificate. It is not the case that district inspector of school is not aware.
Come to paragraph 7. Instead of raising your voice, come to paragraph 7. Please read the observations of the Honorable Division.
What appears to us that both the school authority and the appellants making allegation against each other in order to stick the responsibility entrusted upon them.
In order to shirk their responsibility entrusted upon them. Yes.
Ultimately, it was found that there was no misutilization of fund by the appellant when she was holding the post of headmistress, and no liability was issued after nearly 3 years from the date of attainment of superannuation.
So this is the observation of the appellate court. And you are raising your voice. I will put further cost upon the school authority.
My lord, they have, my lord.
I will, if you go on making submission in this fashion, I will impose further cost.
My lord, it is my prerogative to argue for your lordship, my lord.
Yes.
What is the submission before the trial court?
My lord,
Your lordships kindly have a look, page 51, the school authority submission.
কোন পাঠায় বলছেন স্যার?
In my writ petition.
So there is no objection of the school authority.
My lord, now kindly turns to page 46 once. Earlier order of the Honorable Court. 46.
No, I will not go anywhere.
Because
come to paragraph 7.
Division bench has already
Yes.
sir.
Teacher as headmistress. Headmistress retired for 3 years, no liability certificate was not issued.
If you was issued, no liability certificate.
We know very well the reasons.
See, my lord, when the almirahs was broken, my lord, in presence of the district inspector of school in 2023.
So file an application before the Honorable Division Bench for review, so that this observation can be deleted.
তপতি সামন্ত আর স্টেটের স্টেটের রেজাল্ট ছিল তো ওটা ভুল করে গেছে তপতি সামন্ত পরে কারেকশন হয়েছিল, পরে ওটা কারেকশন করে দিয়েছিল।
Yes, when you will make the payment first, because already you are in contempt so far the order of the division bench is concerned. Because one thing is correct, that these two things are, two directions are independent directions. So it is not the direction of the Honorable Division Bench that first fix the responsibility and then make payment. So in terms of the order dated observation made in paragraph 10 of the order of the Honorable Division Bench, state to pay interest for a delayed payment of gratuity to the appellant, which shall be calculated at a rate of 7% per annum from the date of superannuation, that is 30th November 2020, till the actual payment is made. Such payment shall be made to the appellant within 3 weeks from there. So when he will make payment, then I will consider it. Yes. When he will make payment of interest. Because it is not that there are two separate proceedings. One is payment of interest within 3 weeks. Another is payment. Another is fixation of responsibility upon the responsible person. These two things can go simultaneously. But since it is found by this court that in terms of the order dated 20th November 2024, 3 weeks have already expired. So first make payment. Then court will decide the validity of this order. It is not dependent upon fixation of responsibility upon the school authority. It has to be paid within certain time. When you will make payment of interest.
কথাটা বলছেন তো আচ্ছা প্যারাগ্রাফ 10 টা পড়ো এই টাকাটা কখন দেবেন প্যারা 10 টা 7% এর গ্র্যাচুইটি অ্যামাউন্ট অফ ইন্টারেস্ট
Issue. I am giving 10 days time to make payment of interest to the petitioner, to the respondent number 4. Yes. 10 days.
3 weeks time division they just given my lord 4 weeks time
10 days. First make payment. Not that you have to realize the money from the school and then make payment. That is not the purport of the order of the Honorable Division Bench dated 20th November 2024. In the writ petition, order dated 17th February 2025 of the District Inspector of Schools AC Kolkata is under challenge, whereby responsibility has been fixed upon the authority of Beleghata Deshbandhu Girls High School, Kolkata, for payment of interest due to delay caused in releasing gratuity to the respondent number 4.
Yes, just one.
To the respondent number 4, being the erstwhile headmistress of the aforesaid of the said school. Opore herein after referred to as said school kore dibun. Being the erstwhile headmistress of the said school, comma, at the rate of 7% per annum from the date of superannuation till the date of actual payment is made. From the date of superannuation till the actual payment is made. Till the actual payment is made. Stop. Next paragraph. Challenge has been thrown by the petitioners based on the observations made by the Honorable Division Bench. Now, challenge has been thrown by the said school authority. Challenge has been thrown by the said school authority in the present writ petition against the order dated 17 February 2025 of the District Inspector of Schools AC Kolkata, based on observations made by the Honorable Division Bench in paragraph 10 and 11 of the order dated 20 November 2024, passed on an intra-court appeal being MAT 110 of 2024 within bracket Minoti Boiddo versus the state of West Bengal and others. Close bracket. It is contended that payment of interest due to delayed payment of gratuity to the respondent number 4 is not dependent upon fixation of responsibility for delay caused in releasing retirement dues due to failure on the part of the said school authority to issue no liability certificate within time. Stop. Next paragraph. For better understanding of the issue involved in this writ petition, paragraph 10 and 11 of the order of the Honorable Division Bench dated 20 November 2024 is quoted below. এই যে প্যারাগ্রাফ 10 and 11 টাকে কোট করে দেব। It is clear from the observations made by the Honorable Division Bench that notwithstanding fixing responsibility upon authority/person for causing delay in releasing retirement dues to the respondent number 4. In releasing retirement dues to respondent number 4, state authorities were directed to pay interest at the rate of 7% per annum for delayed payment of gratuity. Within 3 weeks from the date of passing order by the Honorable Division Bench on 20 November 2024. Stop. This court finds that the period stipulated by the Honorable Division Bench has already expired. Next paragraph. District Inspector of Schools AC Calcutta as well as Commissioner of School Education West Bengal, being respondent numbers 3 and 2 are directed to pay interest strictly in terms of the order of the Honorable Division Bench dated 20 November 2024 by 10 days from date. Stop. Next paragraph. Validity of the impugned order dated next paragraph. Validity of the impugned order dated 17th February 2025 of the respondent number 3 is to be considered on the next date. Next paragraph. List the matter under the heading motion on May 2025. First pay. Benefit is accrued in favor of respondent number 4 due to the writ petition filed by the school authority. Yes.
Item number 16.
But the petitioner was a groupie staff of Madhakalika Balika Vidyalaya. He was joined on 13th May 1979. And thereafter, due to deregulation, he has been transferred to the government sponsored Maldives Royal Turkish School. And there is a two different ID, employee ID. This earlier school and another is transferred to the Turkish.
Use microphone.
Yes, my lord. Firstly,
What you are praying for?
I am praying for the revised new pension pay matrix under 2000. Revised new pension pay matrix.
Revised pension?
Yes, my lord.
When you have retired?
I am retired on 28th February 2019.
20th February
2019.
20th February 2019.
Yes.
Now you are receiving pension under
Yes.
which ROPA? You are receiving pension under which ROPA?
Old ROPA.
Which old ROPA? ROPA 1990 or ROPA 81?
No,
which ROPA? You are receiving pension under which ROPA? ROPA 81, which effected from 1st of April 1981. Yes?
Yes, I'm not aware, my lord. I'm taking the instruction.
If you are not aware, then why you are opening your case?
Yes, my lord.
You are before the High Court?
Yes, my lord. I'm not. Only not.
You are receiving pension under which ROPA, and under which ROPA your pension is required to be consolidated? Tell me. It is not a place for holding conference. Yes.
I am praying for the RUPA. I am petitioner praying for pension benefit under the RUPA 2019.
Petitioner is
praying for pension benefit under RUPA 2019.
Show me that you are not. You have not been sanctioned benefits pension under RUPA 19.
Yes, my lord.
Under which ROPA you are getting pension?
I am not taking the instruction.
Yes.
Praying for time to take the instruction.
When the pension payment order was issued, where is the pension payment order? Where is the pension payment order?
I have not annexed. Only the.
You have not annexed pension payment order?
No, my lord.
Then how the issue can be decided?
I am praying for only make a reaction to.
You are speaking for consolidation of pension, revision of pension, and your pension payment order has not been annexed.
No, my lord.
Withdraw the writ petition, file afresh.
Or can we give the liberty to file the supplementary?
No, not at all.
Or can we
that is the basic issue thing.
My lord, I am praying for.
Where is your pension payment order?
Well, I am not annexing petition, not supplying.
Then?
Well, I am praying for only not today, my lord.
That will not change the scenario. Yes, what is your instruction?
My lord, can you come page 14, my lord. Can you come page 14? করা হয়নি।
So petitioner is receiving pension under ROPA 2009?
I hope so, because it is actually there is no PPO is annexed here. So further what he.
You hope so?
Yes.
There is no instruction.
But I have not got instruction yet.
Then where is the pension payment order?
Well, kindly bring for not today, only not today, my lord. Then I will satisfy you, lord. Kindly, lord.
How you will satisfy? It is not part of record.
not part of the record.
How you will satisfy?
No, the other your lordship.
You are seeking consolidation of pension without annexing pension payment order. How you will satisfy? Withdraw the writ petition, file afresh. Otherwise, I will dismiss it with heavy cost.
So, my lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. During course of hearing, learned advocate representing the petitioner has prayed for accommodation to learned advocate for the petitioner has prayed for leave to withdraw the writ petition with liberty to file afresh. Next paragraph, state respondents are represented by learned advocates. Next paragraph, having considered the submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with liberty to file afresh with better particulars on self-same cause of action. Next paragraph. Parties to act on the server copy of this order downloaded from the official website of the school. Next.
Item number 17.
I'm appealing for the petitioner. Can you permit her to address my junior? I'm not well.
Yes.
Can you permit me, my junior, to address your lordship?
Yes.
I'm not well.
So, main contention is valid. The petitioner is an assistant teacher of geography at Baliara Kishore High School. Now, my lord, if your lordship kindly sees the pay slips, her basic pay has been deducted.
What you are praying for?
I am praying for recovery of the overdrawn amount that has been deducted illegally. I am praying for 10 years of incremental benefit which the petitioner ought to have got in the year 2023 for a continuous period of 10 years of service. And another thing is, my lord, if your lordship kindly sees,
You are still working?
still working. The basic has been deducted, my lord. The basic
Who has deducted the basic?
from the school authority, my lord. My lord, kindly sees, my lord.
You are for the school authority? Yes, basic has been deducted.
Basic has been deducted.
On what basis you are making such submission?
My lord, on the basis of the pay slip, my lord. From the pay slip, it is.
So what is your qualification? What is your educational qualification? Show me your approval memo.
My lord, it is at the appointment letter if annexed, my lord.
Show me your approval memo sanctioned by the DI.
That is not annexed.
Why not? That is the basic thing from which it can be ascertained that which scale of pay was accorded to you.
But my lord, from the my lord, subject to correction, my lord, from the.
Where is your approval memo?
My lord, kindly gives me liberty. I shall annex.
Why you have not? You are saying many things, but you have not annexed the approval memo. In the approval memo, DI, in consideration of your educational quality, you may be PhD degree holder, but if you are holding the post of past graduate, holding the post meant for past graduate teacher, you are not entitled to get any pay commensurate in your qualification. So that's why, to ascertain this, the approval memo of DI is required to be annexed. Where is the approval memo? Do you have the approval memo of the DI in connection with the appointment of the petitioner? Yes.
Honors graduate.
Or maybe honors graduate, but if she is holding the post of past graduate post, then he or she will not get honors graduate scale of pay. So that's why the approval memo has to be shown.
I completely understand what has fallen from your lordship, my lord. But if your lordship kindly sees the case slip of the petitioner.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner has raised grievance relating to fixation of her pay, and it is submitted that the pay of the petitioner has been downgraded by the authority of Baliara Kishore High School within bracket HS, South 24 Parganas. Next paragraph. On perusal of the writ petition, it appears that approval memo accorded by the concerned District Inspector of Schools AC at the time of appointment of the petitioner is not annexed to this writ petition. Stop. Court desires to consider the approval memo which was accorded by the concerned district inspector of schools within bracket AC in support of appointment of the petitioner as an assistant teacher of the aforesaid school. Next paragraph, learned advocate representing the petitioner has prayed for accommodation to has prayed for leave to file supplementary affidavit, including to file supplementary affidavit in order to bring on record approval memo accorded by the concerned district inspector of schools within bracket AC in support of appointment of the petitioner as an assistant teacher. Next paragraph. Let such supplementary affidavit be filed by 10 days from date with an advance copy upon the learned advocates representing the parties. Next paragraph lists the matter under the heading motion in the monthly combined list of May 2025. Next.
I'm grateful, ma'am. Thank you.
Item number 18.
My lord, I am appearing for the state.
Yes, yes. Who is appearing for the school authority? Disciplinary proceeding?
I am for the board.
You are for the board?
I am from the state.
Yes. Who is appearing for the school authority?
Can see the cost title, my lord?
Show me service upon the school. Okay. Show me service upon the school.
Can see the order? Order passed upon as a person who is the headmaster. Writ petition filed in the name of the headmaster, my lord.
Where is the service upon the school authority?
This man penalty has been awarded against the headmaster. So other members they will come here. Children of the school.
91930.
Headmaster is the secretary, Miller. So president has been submitted the copy. But I have put it one.
Let you. Interest.
Yes, this is the postal slip. What is the tracking report? One nine one.
No.
One nine. Yes.
I am submitting, I have already prepared a statutory appeal before the commission of school division. But
Against which order?
against the order, that is your order carried on page 77. This is the order passed by the president.
President of?
Board. The Supreme Court of Secondary Education.
Page 77.
77. This is the order penalty. Usually the free again imprisonment has been stopped at this rule.
Page 7. Just a minute. So 3 annual increments have been withheld. Yes. So if you have preferred an appeal, then why you have filed a writ petition?
25th of September, I have preferred appeal.
Yes.
The rule says that it has to be disposed of within 90 days.
So you have come for early disposal of the
My
appeal.
lord, only this prayer I made.
So show me the appeal provision
My lord.
under 2018 rules. Previously there was an appeal committee. Now appeal committee is not there. No, not there. Yes, show me the appeal provision.
Kindly have a look. This is the appeal provision, my lord.
Yes, yes, I have the copy. Which rule?
Lord, at page, my lord.
Which rule of 2018 provides appeal against the order of the board? Rule 10.
Page number 8, your lordship, kindly have a look too.
You have preferred the appeal within time, within 3 months. Now, who is the appellate authority that has not been defined in Rule 10?
First by your lordship, come back to
Yes.
page number 1 of this notification.
Yes.
We'll do one short point title, my lord. Short written.
Which rule?
This is, my lord.
Oh, appellate authority means the commissioner.
Only one thing, page 70, this order has been passed against Sumit Kumar Ghosh. This appeal also filed, this Sumit Kumar
Order has been passed?
against Sumit Kumar Ghosh. Well, he is the headmaster.
Yes.
But appeal also filed by the Sumit Kumar Ghosh. A writ petition is filed in the name only the headmaster. Can you see the cost title?
Let the appeal be heard.
That should be named by name.
So the commissioner of school education is the appellate authority. When you have preferred the appeal, show me.
25th of September 2070.
78.
It's a stamp.
Just a minute. Yes.
78.
Page 78. 25th September.
25th September, I have already filed.
period of limitation was up to 20.
I have received it, my lord. Thereafter, I charged 90 days.
When you have received it?
2nd July. Well, it is left hand side.
July, August, September. Period of 3 months expired on 20th of September 2024. You have filed on 25th September, but there is a provision for condonation of delay. Within a period of 3 months from the date of receipt of the final order, provided that the appellate authority may entertain appeal even after the period of issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Ms. Usha Maiti, learned counsel representing the petitioner, submits that the petitioner has suffered a punishment order and has suffered punishment video order dated 21st June 2024 passed by the President Ad Hoc Committee, President, Ad Hoc Committee, West Bengal Board of Secondary Education on conclusion of disciplinary proceeding, which was initiated against the petition. Stop. The President directed to withhold 3 annual increments of the petitioner. Stop. Being aggrieved by said order of the President of the Board dated 21st June 2024, an appeal was preferred before the Commissioner of School Education West Bengal in terms of Rule 10 of the West Bengal Board of Secondary Education within bracket appointment, confirmation, conduct and discipline of teachers and non-teaching staff, close bracket, rules 2018. এটা দেখে নেবেন, rules 2018. It is further submitted that in terms of Rule 10 of the aforesaid rules of 2018, appeal is required to be disposed of within 90 days from the date of filing from the date of its filing. Stop. In the present case, next paragraph. In the present case, though appeal was filed in terms of Rule 10 on 25th September 2024, but till date, same has not been disposed of. Next paragraph. Stop. State respondents and board are represented by learned advocates. Next paragraph. Commissioner of School Education West Bengal, being the appellate authority, is directed to dispose of the appeal preferred by the petitioner by
since July, second time, this will be deducted.
By
June 30, UPL also possible.
8 weeks from the date of communication of this order, after granting due opportunity of hearing to the appellant and the disciplinary. Stop. Writ petition stands disposed of. Urgent xerox.
July, the first again,
ultimately, if it is set aside, you will get back everything. Next.
Item number 19.
I am for the state.
So I am for petitioner. This is my immediate survey.
Sleep on the
I have served up all milord, but the school where the village is appearing milord, but the school milord she is working milord. He has received, but milord postal received milord doing the service.
Yes, service is not complete.
I have served on all. But milord, the school where his petition is working, they have received on 21st. But the milord postal received milord paying so. Milord, the milord effective response is milord SSC.
Transfer.
Transfer of headmaster milord.
Transfer of
headmaster.
Yes.
On special ground. Milord,
have you made application on portal?
No, milord. Milord.
On offline application. Where is the offline application?
Milord, application is milord. Page milord, page 20. Milord, it was referred. And milord, next 21 milord, the filled up forms.
In 2018 application.
Steps are taken by the authority.
What you are doing for such a long time?
They are saying that
you have made an application 7 years back.
Milord, they have taken milord in 20. They have taken step 21.
What steps they have taken?
They have taken some milord. They have requested the school milord commission requested milord SSC to take steps where the vacancy is available. Milord,
but that rules are not there. You must have made an application to the Commissioner of School Education.
Milord, I have milord.
Yes.
Last milord I paid.
Yes, Commissioner of School Education prayer for transfer. Now Commissioner is not the authority.
Milord.
Now the school service commission is the authority.
Milord, I have served upon the school.
No. After 7 years, this cannot be entertained. Sorry.
Milord,
where is the explanation of delay?
Place 34 milord.
Where is the explanation of delay?
Delay milord, they are taking steps. They have stated that milord, one vacancy is available in milord Puro Midnapur. Milord, they have taken steps.
Where is the explanation of delay? That you made an application for transfer on 1st of October 2018 and you have filed the writ petition on 9th April 2025 after 7 years. Nearly after 7 years.
As they have taken steps, milord, I have not milord.
Sure.
I am waiting milord for the
affidavit service filed on behalf of the petitioner is taken on record. Next paragraph.
Consider milord so that milord,
petitioner has
on special ground
made petitioner being the headmaster of a secondary school has made an application for transfer on 1st October 2018 before the Commissioner of School Education West Bengal, and the same was not, and according to the petitioner, same was not considered contemporaneously. Stop. Petitioner prays for একই সঙ্গে petitioner prays for consideration of his transfer application now by filing by filing a writ petition, by filing the present writ petition on 9th April 2025. Stop. On query being posed to the learned advocate, by delay was caused in approaching this court since application for transfer was made on 1st October 2018, but the writ petition has been filed on 9th April 2025, precisely 6.5 years after transfer application was preferred by the petitioner, comma, no explanation, no plausible explanation is offered. Next paragraph. During pendency of the transfer application, procedure for transferring teacher/headmaster is altered. Stop. When petitioner made application for transfer on 1st October 2018, said same was preferred before the Commissioner of School Education West Bengal, but at present concerned authority of the West Bengal Central School Service Commission, West Bengal Central School Service Commission is the appropriate authority to finally decide the transfer application of the petitioner. Stop. Next paragraph. In view of delay caused in approaching this court, no relief can be granted to the petitioner and the writ petition stands dismissed.
Page 30.
However, this order shall not preclude the petitioner to apply. However, this order shall not preclude the petitioner to apply for transfer afresh in accordance with law. Urgent xerox.
Page 34 is there. I have applied.
Next matter.
Item number 20.
But this is my affidavit of substance report.
Time for the school service.
Yes, my lord. It is very unfortunate, and I must say, my lord, I required some your lordship's marks. My lord, in 2016, your lordship knows advertisement for classes 9-10 upper primary were published. I applied in both. In the meantime, in 2019, my lord, I was appointed in class 9. Thereafter, my lord, the upper primary process also I appeared for the interview, but in 2020 it was cancelled. In 2021 it was again started. I again applied. Thereafter, I was called for
applied for
upper primary, my lord. I was called for.
You have got the job.
No, my lord. I'm my lord.
In 19.
19. I again,
got the job at the relevant point of time.
Yes, but
19.
still I applied. I want to be in upper primary. I applied.
So, in spite of working in class 9 and 10,
9
you
and
wanted
10.
to be a teacher of upper primary level of
upper
schools.
primary level of
What
school.
for? What is the reason for that?
Reason was in 9-10 I am a lady, my lord. I was posted very far, very far. And secondly, there was some litigations going on. So I want to on merit, if it is possible, I want to bear in the upper primary. In 2021, and I applied. I called for interview, but initially when the interview was taken, SSC said that no, you are an in-service candidate, you will not be allowed to participate. I approached this court. Your lordship, following the rules, allowed us to participate in the interview, and ultimately the School Service Commission accepted that order and allowed everybody, my lord. Thereafter, I participated in interview. My interview was taken. I was called for counseling. At that point of time, my lord, litigations were pending regarding upper primary before the division bench. I participated in interview. I was called for counseling. Counseling was held. First phase counseling. In the first phase, I was called considering my rank. In the meantime, but since even after the first phase counseling, the division bench finally directed you conduct fresh counseling. In the meantime, my lord, two things happened. In the meantime, on April 2024, my appointment was cancelled. 9-10. Everybody en bloc cancelled. Supreme Court appeal was pending. In the meantime, my lord, in September 2024, 19 September, I was blessed with a girl. My lord, I was released on 19 September 2024. Thereafter, my medical report is there. I suffered heavy bleeding. I was facing problem, my lord. Baby feeding, my lord. There was a serious problem. Document is there, my lord. Next counseling, I was called for the counseling in the month of November 2024. But my lord, because of, it's not that I sat tight. Because of this situation, my lord.
Counseling,
fresh counseling for upper primary. Again, second time, I was called.
So that is, yes,
after
counseling is complete now.
Now counseling, no, it is still going on, my lord. It is still going on. There is vacancy, my lord.
Maybe there is vacancy, whether the counseling is continuing.
Yes, my lord. Fifth counseling was conducted 1 week back. The commission can say, my lord, whether they will conduct fresh counseling.
Mr. Dr. Patra, the counseling is continuing.
The panel is still alive.
90%.
Panel is still alive. So naturally, if we get vacancies, we will follow 6th phase of counseling.
So whether the petitioner can be permitted to participate in the counseling in view of the special circumstances as it
we
has been
will
narrated
face
on the
huge trouble if we start accepting. Already 2 matters my lord has directed me to discuss with the chairman whether something can be that candidate who had twins was absent at the time, etc. So, and what my learned friend is submitting also.
Because question is that the petitioner is a selected candidate. He was an eligible candidate to participate in the counseling, but she could not turn up. Now, in subsequently, whether counseling,
we have
why petitioner will not be permitted.
No, her permitting her might mean permitting another, say, 500. And permitting another 500 would mean...
Yes, because the zone of consideration will be wider.
But
you will get better
candidates. 500 will result in depriving the 500 who are waiting.
But they are not, if they are not coming within the zone of consideration, including this.
They are in the zone of consideration. And
so why they will be
basic
deprived?
content-
Because counseling is to be on the basis of 1:1.4.
Why they will be deprived, I'm telling my lord. The candidates in the waiting list, there is no surety that they will be getting the opportunity. Their opportunity comes from absent candidates and non-joining candidates. Now, their expectation that the non-joinings are coming and we are in the waiting list, maybe at the bottom even. The last candidate in, because the direction is I am to appoint all of the candidates in the merit list. Because we had...
No, but in this type of matters, case-to-case basis, it has to be considered.
Yes, then let
because
me file...
if the petitioner is not an eligible candidate, but due to the reasons which were beyond the control of the petitioner, she could not appear. Otherwise, he was selected candidate for the purpose of participating in the counseling. Why the commission will deny her right to be counselled?
We cannot allow the candidates to come in now. We cannot. Let me file a report.
It is too technical approach so far commission is concerned.
My lord, in the present scenario, a little technical.
It's too technical, Mr. Dr. Park.
Let me file a report.
Because,
let me take instruction.
Because you are saying that others are waiting in the queue. They are waitlisted candidates. There is an expectation so far those waitlisted candidates are concerned to offer their candidature. I could understand that if petitioners are not coming within the zone of consideration, because other waitlisted candidates will not get opportunity for which the petitioner, being a listed candidate whose name is appearing above waitlisted candidates, will be deprived of getting opportunity to participate in the council in a special circumstances.
Lord, let me file a report. Let me take instruction. And
when your counseling will end?
Counseling is over at the moment. The fifth phase counseling, it was for 1 day. It was in
when it took place.
It was in the first week of April.
16th of April.
16th, still okay.
16th April.
Yes, maybe. I can't remember.
Then the next date has not been fixed.
Now, naturally, we have to wait for the non-joinings and everything to come. And
so let me pass an order permitting the petitioner to participate in the counseling.
Kindly do not.
In the event any counseling is
500 will come or 5,000 will come. Because visualize one thing. Candidates who were successful for classes 9, 10, 11, 12, they are much more talented, if I may use the term.
Better candidates.
Than the other candidates who are
not
now
talented but better candidates.
Yes. Now, if they are allowed to come back, then these candidates who
because all the candidates, other candidates, most
a huge influx.
Those who were selected in class 9, 10, 11, 12, most of them participated in upper primary.
Yes, yes. Large number. I can't say most of them, but a very, very large number.
Now, since they have lost their jobs, they will
yes, that is the
try to take a chance.
The U-turn, and they waited till the 11th hour. They did not react in the division bench set aside.
My case is not that.
They reacted after the Supreme Court judgment came.
My case is not that, my lord. Even when
when you gave birth to
after my
the
lord,
baby girl,
two things I am clarifying, my lord. First,
in which month?
September 2024.
So what you were doing for such a long time?
My lord, thereafter, I filed writ petition so that I could be allowed to participate. I participated in the initial counseling in 2024.
No, after September 2024.
Yes, my lord.
So you were fit from November 2024, October for 2 months. You were not fit medically, but from November 2024 you are fit. So from November, why you have waited till April?
Not that, my lord. From November 2024, I was, my lord. If you're live, I can say, my lord, it was serious problem feeding. Regarding some breastfeeding, my lord, I had serious issues as well as.
Please should not take these grounds.
My lord, this is
because I cannot reply to them.
My lord,
I
am not taking.
Court has also difficulty to give.
Yes, my lord. That is why I am not. My lord,
everybody has a problem.
My lord, this
everybody,
is not
even
that
a problem. But I still think to
not that.
Argue my cases.
After I was terminated, I sat tight. Once the Supreme Court.
No, court is asking that from November 2024, why you have taken time till April 2025 to respond.
My lord, to be very honest, my answers, I was facing that problem.
5 months.
That problem.
Mr. Dasgupta, 5 months.
Yes, my lord. That problem is one. Definitely, that problem is one.
It
problem.
goes to show that you are waiting till the fate of that selection
my lord,
process.
with deepest of respect, if that would have been the case, I would have not approached the court. Allow me to sit in the interview. I would
file your report.
My lord, if the seats are filled up, my lord, then it will be a great difficulty.
No, because you are not your alacrity is not
Kindly
established.
Give me some protection if seats are filled up.
No, sorry. Affidavit of service filed on
Lord,
behalf
if
of the
seats
petitioner
are
is
filled
taken
up,
on
my
record.
lord,
Next paragraph.
kindly give me that
Petitioner
protection.
being an impaneled candidate for participating in counselling.
Lord, I lost my job for the fault of the SSC, and now I am facing
state
this
level selection test 2016 upper primary has belatedly approached this court seeking direction which would permit her to participate in future counseling if conducted by the West Bengal Central School Service Commission. Stop. Next paragraph. It is found that petitioner got job in connection with her participation in first SLST 2016 for classes 9 and 10.
And my lord, another thing
for classes 9 and 10, but the said selection process has been set aside by the Honorable Supreme Court with a judgment dated 3rd April 2025. Now, next paragraph. Question arises for consideration whether at this belated stage, petitioner should be permitted to participate in the counseling in connection with first SLST 2016 upper primary within bracket. First SLST 2016 upper primary. If in future any counseling is conducted by the commission. Stop. Next paragraph. Dr. Patro, learned advocate representing the commission, has prayed for accommodation to file a report. Next paragraph. Let such report be filed by 2 weeks from date. List the matter under the heading motion on. May 2025.
service may be. I have also pleaded. My name is not in the list of tainted. I have annexed my OMR. I have annexed my merit list. Everything.
That is not the issue here.
No,
the advertisement clearly stated that if you are in a higher post, you
my lord, that they have modified. They cannot say that they have notified pursuant to a
but
judgment
you
of the High Court.
participated with the knowledge that if you join 9, 10, 11, 12, you will not.
No, that has been modified, my lord. Subsequently, your lordship's order, your lordship passed that order.
Solve the issue.
My lord, Supreme Court said if you are tainted, and on another occasion, my lord, another thing, Supreme Court given some protection that if you are a non-tainted candidate, then you can revert back to your old. Considering that special circumstances, there is no fault on my part. Kindly consider that. I have also stated
last part of the judgment.
Yes, paragraph 47.
For those who were in
working.
I accept
leaving their previous job. Those who
previous job. My lord.
No, whether that principle can be applied here, considering the plight of the petition.
Yes, that is
Dr. Patro.
Yes, the copy of the judgment.
Yes, I have.
Disputing it. That is the only reason why we are still arguing the matter, considering the matter.
When an opportunity is there.
But not at the cost of others. That is.
At the cost of whom? If they are better placed candidate in the list, then I could understand. At the cost of the candidates whose names are appearing below the petitioner. Whether in this situation you will refer the term cost.
No, yes, because after 5 rounds of counseling,
the
lower rank candidate is he's at the doorstep of his employment. these candidates will now come in and push them 500 ranks
But see the
behind.
predicament and the plight of the petitioner also who has lost the job.
True, absolutely true. They are victim of circumstances. That's
When one window is there in the midst, why that will not be opened for the petitioner? Try to
no, that is
be
in my
reasonable
mind.
before
This
this
is in
court.
my mind. But I have to think of all. That is the problem.
No, I could understand. If there are 10 candidates who are above the petitioner, they will be deprived. Then question would have been different. Petitioner's position in terms of merit is better than the candidates for which you are arguing.
Rank 61, my lord, in the main
Dr.
panel,
Patro.
not even in the waiting.
File an affidavit, report. Don't pray for time.
No, I will.
On the next date.
Deeply.
Item number 21.
A light can be seen at the horizon after losing job. So consider this.
21 round for the petitioner, Lordship. Claiming the arrear pension from the date of retirement instead the date of refund after converting to contributory provident fund to general provident fund.
Yes. Order. Assistant teacher.
Assistant.
When superannuated?
30th April 2011, Your Lordship.
He or he?
He.
Pension payment order?
4th June 2015.
Hello.
Yes, disposed by show. এটাকে ফলো করে দেবে ওই কালেকশন গুলো দেখে পড়ছো না ডিসপোজড অফ নেক্সট হ্যাঁ উপরে আছে দেখবি ওটাও করা
Item number 22.
I am for the
Yes.
My lord, I led by Mr. Arindam Chakravarti. This is my evidence of silence.
Yes.
The fact is that the petitioner already retired from the school Interim order is page 65. Petitioner initially worked as an assistant teacher in the DA school, that is Scottish College School. Thereafter, he was selected by the School Service Commission as a headmaster in his aided school. And from the aided school, he has retired. Now he is asking for pension, but the DI has refused to get the pension. That is last annexure, page 65. Para 3.
Now, your service in the previous school, in the DA getting school, was an approved service.
Yes, approved service.
Just a minute.
I have a judgment also, and division bench already tested, allowed in favor of me. I have annexed that document. But can you see the paragraph 3?
Petitioner, you are for the state.
Yes, my lord.
Now, the petitioner worked as an approved assistant teacher in a DA getting school.
Yes, my lord.
Reckoning his service in being an approved assistant teacher in a DA getting school, he was found to be eligible to be appointed as headmaster in a government-aided school.
Yes, sir.
Then, while computing pension or taking decision relating to release of pension, why such period will be excluded? Because the requisite qualification for being appointed as a headmaster in a school is 10 years approved service in a recognized school. Unless and until that condition is fulfilled, a candidate is not entitled to be appointed as headmaster of a school.
That is
now, why you are recognizing his past service as an approved service
that is
in a recognized school, then why it will not be taken into consideration in computing the pension of the petitioner?
not only DC.
I have passed at least 2 orders.
Yes.
One in case of a school in Durgapur that was under sale probably, and there is a similar.
I have seen the order of the district inspector school only relied on the DCRB scheme, my lord. Only your lordship is rightly pointed out when we are considering his 10-year service, though my respectful submission, that is only for our qualification that she rendered 10 years continuous service. That is why, my lord, the see, my lord, that is why. But DCRB scheme, my lord, there is no specification whether the when she, my lord, he renders her.
Where is your approval memo in connection with your past service?
Approval memo, my lord?
Yes.
10 years. And before it is the assistant teacher. Thereafter, my lord, kindly see. That is page 22. As a headmaster, my lord.
No.
Approval or appointment?
Approval in past service as an assistant teacher in DA getting school.
That is page 20, my lord, kindly see.
Page
20. 29th August 1997. Serial number 4, Kishindu Jana. His service has been approved. your lordship judgment as well as also Justice Jyotirmoy Bhattacharya judgment, and that judgment also tested by the division bench.
Show me
I have already annexed.
That judgment annex the single bench something is different because and that judgment the teacher concerned previously was my lord the in a school aided school subsequently
No,
DA
no, 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 no. Certainly not. No, you are wrong.
No.
You see,
I have seen.
62 pages. That is Joy Prakash. Also same. Identical.
But the past service of the petitioner was also an approved service by the district executive school.
Yes, but that
protection also given, my lord.
Kindly come to 60.
And pay protection was also given. See?
Kindly come to that judgment, referred judgment.
Calcutta DI is already giving the same.
Page 60.
60.
Calcutta DI is already giving the same benefit in number of teachers in the similar circumstances.
As such, the government order dated 19th April 2006, in my considered view.
Where?
Page 60.
Page 60, just a minute.
In page 5.
Yes, place it.
As such, the government order dated 19th April 2006, in my considered view, has no application in the facts of the instant case as admissibility.
As admittedly, the petitioner
initially served in DA school and thereafter in aided institution, wherefrom he retired. As such, petitioner right to get pensionary benefit with emanates from the government order dated 20th May 1988 cannot be denied by the state. The court holds that the district inspector of schools misinterpreted the provision contained in the government order dated such and government order dated 8 January 2007 respectively. The impeachment order is absolutely legal. Well, at that point already
The 19th April specifically says.
Just a minute.
And you come to page 66.
Just a minute.
Can you see the page 59 of the judgment?
Now, this order was appealed against.
Yes, I have already annexed. Next page, page 62.
What was the decision taken by the appellate court?
That is division bench order.
Dismissed.
Yes.
Dismissed.
And the petitioner already enjoying the pension blood.
In that matter.
That matter. The same DI
Yes. So it is decided by the coordinate bench already. That was tested before the appellate court. So why your DI has taken such decision?
Because that decision was not placed before the that decision was not placed before the
Your DI is also not considering the special bench judgment in higher scale matters.
Yes.
Regularly, I am finding cases that a postgraduate scale of pay is being denied in spite of in the second round of litigation. In the first round, court has directed to follow the decision ratio of the division bench as well as the special bench. In spite of that, by incorporating certain other extraneous points which are not relevant, this the effort of the teacher to get postgraduate scale of pay is being frustrated.
That cannot be done, madam.
Now see the position in the present case. Yes. The petitioner was an approved assistant teacher in a DA getting school. In reckoning his past 10 years approved service, he was selected for the post of headmaster in another school. Now Ms. Das is submitting that at the time of fixation of pay of the petitioner in the second school as headmaster, past service was reckoned and pay was accordingly fixed, giving pay protection. Then at the time of granting pension, it is being an order is issued by the DI that your service is less than 10 years, which is not a pensionable service.
Decided by DCRB school, mother. DI, mother, that point was not placed before the DC.
So DI will not apply his mind. In every matter, the teachers and the affected parties have to approach this court.
But these rulings are not being placed.
I have passed at least 2 orders. One in a Durgapur school, another also in a DA getting school, probably.
Similar.
Yes, similar situation.
Reckonable. That
There, the plight of the petitioner can be perceived.
kindly
It will come tomorrow. That will be it will retain its position. Not today, Corridor. Today, I am not passing any order. That's it. Simply not today. It will retain its position.